I am incredibly humbled and grateful that you are on this channel to talk to me, because I know you said that you got a lot of requests from a lot of different places.
Yeah, I mean, and I had mentioned to you, like, I mean, Hannity tried to send people out to me, like, where I was in person that day after the verdict. And, you know, I, in general, don't really feel like I said, I didn't want to be a prop. Um, but also, you know, a lot of it is to correct the record, things like that. I don't, and I mentioned to you this right before the show, is I don't think I'm going to do another interview besides this one. I might end up at some time, but right now I don't foresee myself doing anything else. This is an opportunity that I had to sort of tell my story and correct the record is about some things. But in general, I don't feel like my job is necessarily about me. It's about my clients. How we got involved was there. So I believe it was about the second week in September 2020. Mark got an email from an attorney in Washington, D.C. named Maria Medvin, who had kind of been helping out, you know, researching, vetting people in the area. And she was like, you know, look, we've looked at your background. We want to, you know, at least talk to you. And at the time, I remember Mark wasn't committed either way, but he is somebody who he has done so many trials and he does so well in them. I mean, Attorney Richards has done over 100 criminal trials as a criminal defense attorney, and he's only lost 2 in a row once. So I think that's a really impressive thing. I'll look at a story. First of all, I stopped watching the news. That kind of happened along with this. I think that is there aren't too many, unless you're going into independent people on things like, you know, YouTube, aren't a lot of independent mainstream people. And the reason I'm on your show as opposed to doing a lot of the other stuff that's been asked of me is, you know, I feel like a lot of times people use stories and things like that as a platform for the person who's speaking them, not necessarily to tell the story. Right. And, you know, I didn't want to be somebody's prop. So I didn't want to go on something larger like that because I have a very big problem with the media in this. You know, ultimately, what I've been doing now and, you know, telling my friends is if there's anything about a document and it doesn't link you to the document, it's not a credible source. Because if they are a credible source and are objective, they're going to let you read it for yourself. And especially with all these filings in the case, I mean, anything that was filed on our behalf that was not filed by Corey was written by me. So if you're seeing these things and it's like, that's not what that document said. I know that's not what that document said because I wrote that document. So, and then, you know, looking at these articles and it's like, nobody's letting anybody actually read the document. And so that really bothered me personally.
Yeah. So other than the drone footage, were there any other like surprises that came up during trial that you guys didn't anticipate?
Yeah. Tons of stuff. I mean, the issue with Jump Kick Man, obviously. And that is something, I mean, I'm not going to stick up for the prosecutors here. I mean, as you said in the beginning, you know, I do want to maintain my professionality and things like that. But Kyle had mentioned this, I believe, in his interview with Tucker, I mean, we did not know who Jump Kick Man was until during the middle of the trial. And the state, you know, says they didn't. I don't have any reason to doubt them. But, you know, I really don't know. It's not anything I have personal knowledge on. What happened with that was, I don't remember what day it was exactly because it's kind of all a blur. But the prosecutors called us I don't remember if we called into the back at that time or not. But they had said that somebody claiming to be Jump Kick Man had come forward. And you know, the state hadn't even met with him yet, hadn't confirmed whether or not he was Jump Kick Man. we had a name, and then we had a copy of a booking photo. And we thought this might be this person, but in the videos, he is wearing a mask. So we didn't really know for sure if this is, it could, I mean, with something like this, the amount of crazy people who are coming out of the woodworks, I don't think anybody knew whether or not to believe this was Jump Kick Man until we actually talked with them. And originally, because he was a complaining witness or victim in this situation, the prosecutors wanted to meet with him without us. We had a big problem with that because he'd been, MIA and just surfaced during the middle of the trial. If we didn't want us there, then we wanted one of our investigators there, and they didn't really want that. But Judge Schrader was kind of just like, no, that's not how it's going to be. Like, he offered to have himself moderate a meeting with everybody, but the prosecutors didn't want to do that, and we didn't really want to do that either. So what ultimately was determined was that the meeting the prosecutors were going to have with him would have been videotaped, the whole thing. We would have instantly got a copy of it. My understanding, at least the information that we were provided, was that the state never actually met with the person claiming to be Jump Kick Man, because beforehand, he, through his attorney, had told them, the only way he's willing to even meet with them is if they agreed to give him full immunity for anything he did that night and the crimes he was charged with previously. And they weren't willing to do that. I mean, they didn't really even know if it was him. I mean, I think it was him, ultimately, but they didn't actually meet with him, to my knowledge.
Okay. And then the same thing, I know that there was also a controversy about the Zaminskis, mm-hmm. right? And being able to bring them on. So were you guys, remind me, were you guys trying to get them on as witnesses as well, or?
Well, there's a big problem with the witness list in this case I think the first witness list, I don't remember if it's the first witness list we got or the second. I could look back, but there were, approximately 180 people on it. And of course, they're not going to be calling all of those people as witnesses. We then got and Jump Kick Man was not on the witness list. His name, because I personally went through each and every person on the witness list previously. And, I made a chart with their relevance, things like that. And we got a short list from the state with, identifying who the people they thought they were that they were actually call. We didn't get that until not too long before the trial. And then we got a supplemental short list with doubling the number of people, like a week and a half, 2 weeks before trial. But, the Zaminskis were on the state's witness list. They were never on their short list of people. We had them both under subpoena and, basically on standby the whole trial in case we thought we needed them. But there's a lot more than just what's in the media about the Zaminskis. And, you don't ever want to call a witness who might distract from the issues or is not going to serve you in some way. And there wasn't anything from the Zaminskis that we couldn't get from other people.
Makes sense.
So there are a lot of, like I said, chess game. There's so many factors that are involved in this. And so much of it does involve the jury. I had the best seat in the house for watching the jury. I was literally facing them the whole time. And, I believe in Joel and Demetrius, who's an amazing person who I would love to talk about in a little bit. She was there with us, and she's done a little bit of an interview, at least that I'm aware of. I don't know how many since then. And, she's described a lot of them as being poker faced, but she also, unfortunately, didn't have the vantage point I was in. So there were obstacles sort of in the courtroom that were impeding the people in the gallery from seeing certain things. Like there was that big TV that, people were pointing to and stuff while they were talking to the jury. And part of the problem was just the space constraints in that courtroom is there are certain things that can't be moved. because of it just being a very old building and having to try and like fit all this stuff and these people in here. I mean, if we could have moved some things, there would have perhaps been better use of space, but that's not how the courtroom was designed. Right. So, like that big TV, I think impeded a lot of people from like seeing different parts of the jury. But, like I said, I was facing them the whole time, and there were some people who were poker faced the whole time. I mean, there's one woman specifically that I'm thinking about who the only time I saw her really give any type of genuine reaction to anything was actually when Ryan Balch was testifying, and she smiled at him. She liked him a lot.
Oh, interesting.
Yeah, but she didn't respond to anybody else at all. She was, yeah. So
that's an odd one to like if any of them, I would think.
Yeah, she liked Ryan for some reason, and so much of it was little things like that. Is wanting to make sure that each person had it, if each person's connecting sort of specifically with one person, regardless of whether they're poker faced and the rest of the time, it kind of does inform, your analysis of how things go moving forward, because there were, so many things that you don't anticipate. Like we had a medical examiner who was ready to testify, but Mark was able to successly use Doug Kelly against the state. So
for all intents and purposes, he was your medical. Yeah, he was your witness.
why do we need to call our own when there's the risk of them using him against us? Because you can never anticipate what somebody else is going to say, and regardless of whether or not, working with experts in general is very odd. I don't know if not a lot of attorneys don't have experience with it if they do, contractual things like that. But, to an extent, there is working with experts is an art, and there wasn't anything that we thought our expert that we could get out of him that we didn't already get in a more theatrical way with Kelly.
So let's talk a little bit about the jury. I was so surprised when you guys seated them in a day. Is that normal for Kenosha criminal cases, or was that unusually fast?
That was unusually fast. Part of it was because of the limitations that Judge Schrader had put on questioning for voir dire. We did, and so in the last other, I don't remember, I think it was like the Daubert hearing part 2 or something that was like a week before the trial started. We had more of a discussion off the record with, because we had our proposed questions, our questionnaires that we had proposed previously, and Schrader went through them and, basically axed out about 75% of the things we wanted to ask people. So
such as what? What else did you guys?
I can't even everything.
Just a couple examples, maybe.
There's like some things that you would think would be political. There's the, he almost didn't let us ask. There's always, the typical question is, do you believe that a defendant, is innocent until proven guilty? He was, well, that's technically a political type of question. And
he almost didn't let you ask that?
Yes. Because he's like, yeah. So there was just so many limitations on things like that. And under the circumstances, I think that Corey did a phenomenal job, because we were just so very limited in what we were able to do.
So what was your thinking and what kind of jurors that you were looking for to seat on there?
I wasn't as involved with jury selection. The nuts and obviously involved with the nuts and bolts of it. But we had, and we'll get into jury selection, Joel and Demetrius. If people don't know, Joel and Demetrius is a really big deal. And if there's anybody, I think, who we added onto the case who, if we had to do it all over again, we would use Joellen every single time. And that is something that will remain constant, is, her ability to read people, understand people, things like that is just crazy and phenomenal. She was O.J. Simpson's jury consultant on O.J. Simpson's criminal case. She worked on Kobe Bryant's case. She was the jury consultant for Richard Ramirez, the Night Stalker. Like, this woman,
That's quite a list of credentials.
Yes, this woman knows exactly what she's doing, and she's very, very good at it. And she is one of the most humble and just calming people. I mean, she was like a security blanket for the whole team. Just having her around is, you know, there are certain types of energy that, you know, I mean, I don't have a problem saying it. Certain types of energy that don't work well with me. Certain types of energy that don't work well with Mark and Corey. And she had, I mean, and also for the family, you know, she was so there for the family. If you watch Kyle's testimony, well, I mean, first of all, she was in there every single day of the trial. She went above and beyond. And, you know, she would consult with us at different points in time about different things. But, you know, my mom watching the trial thought that Joelle Demetrius was Wendy's sister because of just like the genuine like compassion and caring that she exhibited. I know that there's been a lot of criticism about Mark and Corey not objecting more during Kyle's cross. And part of that was the jury's response is, I mean, at certain points in time,
I knew it.
At certain points,
I feel so justified.
Yeah, I mean, there were a certain amount of people who, you know, were paying it, who were very, you know, just because I feel like everybody in general was very attentive because they knew that this was a serious case, but you can tell when you lose people, and you can lose people in many different ways. You can lose people by being boring. You can lose people by, you know, asking the wrong questions. And you can also lose people by being mean to the witness. And there was a certain amount of benefit that, well, first of all, Corey and Mark generally aren't big objectors. You know, at least not on a direct, because it really depends upon the circumstances. But a lot of it is, you know, if people aren't paying attention or they don't seem to be picking up on something little, then you don't want to bring their attention to it. Because especially with these jurors, I mean, they were very much picking up on objections. We had a juror note that was a question that was after, I don't remember what point it was, but there was an objection. The jury had to leave the room. And, you know, there was a question that we got, and they wanted to know why the objection was overruled or, you know, had been sustained in that circumstance. And there's a reason why you're not allowed to be in there. Right. So the last thing you ever want to have a jury do is speculate. So if it's something that, you know, is a question that, you know, they've seemed to sort of glossed over a subject in their presentation, their questioning, you know, we're not going to bring it up to other people. And also, I think that there were specifically some jurors who were, you know, who were very much feeling bad for Kyle in the situation because, I mean, and it was something that worked more to our favor, the way that we did things, than it did actually to, you know, it had more of a benefit the way that it was handled, in our opinion.
Okay.
And juries like him. That's the thing is as well, you know,
that's another.
They notice that it's like just the community that we're in is, you know, I know it's one thing to watch the trial and have people have their opinions, and that's fine. But having done trials with Mark, he has an uncanny ability to connect with jurors. And they believed him. And it was something that, you know, a lot of it is idiosyncrasies with the specific place we're in, because of course you're going to get people who are, you know, extreme on either end, but those people usually get struck from juries. And somebody who is able to connect with the middle people who end up on juries is very important, at least in the state of Wisconsin. You know, why weren't we pushing harder for the mistrial with prejudice? Why did we ask for a mistrial without prejudice? So never at any point in time after that was brought up were we not asking for that. It's giving us another avenue and another way to potentially set Kyle up for success, is because the judge had, I mean, Judge Schrader in general, you know, most of that stuff didn't come up until after the evidence had already gone to the jury. And we were confident that there was no way he was going to spoil that jury. He was going to let them deliberate for better or for worse. And the mistrial issues, and he had said that, if there is a conviction, we have to deal with these. So those things were already on the record.
Yeah.
And, let's say, for example, Kyle had been found guilty of something. Judge Schrader could have, after the fact, given us our mistrial with prejudice and, disregarded the jury's verdict, and also could have instead given us a mistrial without prejudice, or, if he was feeling crazy, he could have given us both, technically. I mean, one presupposes the other, but those were never at any point in time waived. And an idiosyncrasy with Schrader is that's, again, if somebody's not going to do something, what do we gain by being, problems about it? Because we weren't being problems with things throughout the trial. Right. And that was, it was something that, like I said, we were confident he wasn't going to deal with it at the time. He wanted it to be a jury decision. And, I think it is of something so important, so much importance that, like, we would have loved to had more time to more extensively brief and research. But part of the problem with all of this is, being bound by where we were at. I mean, we couldn't, our office is, 11 miles away from the courthouse. We couldn't, and for security reasons, we couldn't come and go. We had a room that we were allowed to be, that, we had set aside for us. But, I had bags and so much stuff with us because we had to schlep laptops back and forth every day. We didn't have a printer. The poor court reporter and clerk, who are both amazing people, Tammy and Karen, I don't know how many times I was like, will you please print this for me? So
with having to do with the mistrial with prejudice and then asking for a mistrial without prejudice, what was the reasoning, since you already had the mistrial with prejudice on the record? What was the reasoning for then also asking for the mistrial without prejudice?
Part of the problem with the mistrial with prejudice is obviously politics behind it. And things aren't as easy as just filing an interlocutory appeal. That is, all well and good to say, but, how that actually works and plays out in real life is very complicated. And we knew that the prosecution wasn't going to agree to it. We knew that Schrader wasn't going to grant it at that time. He was going to take it under advisement. So, we got these two things. It gives Kyle another option moving forward, because if for some reason judge didn't think that rose to the level of a mistrial with prejudice, that doesn't mean we can't appeal those decisions, but that takes a lot of time. And if there had been a guilty conviction, if we have to appeal, this decision on whether or not a mistrial with prejudice should have been granted, Kyle would have still been in custody. Mm-hmm. If we're doing a mistrial without prejudice, then he still gets to stay out on bond. So, putting all your eggs into one basket when, because there was granted, I still believe that, it was grounds for a mistrial with prejudice. And I'm not quite sure, what would have happened moving forward with that, because, there are so many variables, and, judge just didn't want to have to make that decision. Yeah. But if we're, going to, I think it was Legal Mindset or somebody had said, you want to throw it up to the faceless, appellate court or something like that. That doesn't serve Kyle. That doesn't, by putting all our eggs, like I said, eggs in one basket is right. Because his safety has been a considerable issue throughout. And, this isn't a situation where they're going to grant a stay pending appeal. Right. So if he had been convicted of something, he would have been incarcerated, and he would have been in risk of his safety. He brings up the end, I think Tucker had asked him, you seem really calm. And he was like, oh yeah, I got to be calm. I can't control everything. If I freak out, then other people are going to freak out. I'm freaking out inside, but the best thing I can do is stay calm. And that's just how he is. I mean, he's not, and I mean this in the best possible way, they're kind of simple people. There's not really any sort of malintentions. And when I first got on the case, that was something else that I thought, because of just the way the media had been spinning everything, that was too convenient, until I actually met Kyle and I met his family. And they are people that just, it's on the surface. They're not overtly political. They are just try and do the best that they can. And, he's somebody who's also very thoughtful and interested in learning things. I remember at one point in time, and I obviously can't talk about communications about the case, but right. This was just something otherwise, I think he had called me or some other person ma'am or something. And I was like, I love the respect there, but you never call a woman who's not a judge or a police officer ma'am. Like, you call them miss. And he was like very interested in why my opinion was for that. And I was like, well, first of all, because it makes me feel really old, so don't call me ma'am. And there's little things like that. He's very receptive to things. And he, because I spent tons of time with him throughout the duration of the case, but especially during, those 3 weeks, we were driving to and from the courthouse with him, stuff like that. And, we have like lives to live. I was like speaking with family and friends and stuff on the phone. He would hear it on the phone. He's like, what does that person you were talking to look like? Like, I just want to put a face with a name. And he's like, oh, and he's like, just like actually very interested, generally interested in, our lives and things like that.
Which is kind of unique for a kid his age. A lot of kids at that age aren't so concerned with what everybody else is doing. It's kind of their age, their friends. And I'm a mom of a teen who's not that old, but it really is a unique, not every kid is that interested in the people around him.
Yeah.
But I imagine how the defendants are when you work with them in cases.
Yeah. And he also, like I said, some of the media stuff I think is, I don't personally know any arrangements about anything, but my belief is that there are some things he was obligated to do. And something else that, has come up a lot is the whole ASU thing and whether or not he was a student in the protests and stuff. I mean, what I can tell people is that he had a biology test the day of voir dire and he was freaking out about it. Like, you wouldn't think that somebody would be like, oh, I have to do this college exam, because it's like, but no, that was an obligation that he undertook. And he was so proud to be in college that, it was something he was very serious about. Getting back to the question, though, I know you'd asked about the PTSD thing, and I'm not going to talk about his PHI, his personal health information.
Of course.
But I was at the trial when he testified. And, there have been different people whose response have been, oh, I didn't see tears. Well, first of all, what definition is these cameras shooting in? I would not expect you to be able to see tears going down his face, because that's just kind of one of those things. And the second thing is, there's so much that gets lost in translation with the mood of a place and an experience when these things are happening. And he, people are like, oh, fake crying, things like that. It's even hard for me to go back and watch it again, because it was real. And when you look at it, he's trying not to break down, which, especially if you're a teenager and you're trying not to break down, might also look at the same type of thing that, if somebody's faking, because he's trying to keep it restrained. It wasn't allowing yourself to necessarily experience your natural emotions. And that isn't going to come across necessarily super well. But I mean, the kid had a panic attack. He had a flashback, and we had so many people reach out to us after the fact that I watched this. I have PTSD. This is, I feel for this kid. And, I've said throughout everything, you know, if people know all the facts of the situation, if they watch the trial, I don't really care what your opinion is. You know, personally, from a personal level, I mean, obviously I want to advocate for my client, but the 12 most important people in the world already found him not guilty. So I really don't, those people are the opinion that matters to me. But you know, if people have watched the trial, who watched the whole thing, who think that he was fake crying, I mean, that's your opinion, but you weren't there.
Now, can I ask you a follow-up on that? Because for me, it rang very authentic, but I've also been in courtrooms and watched people retell like the worst things that have happened to them. And you often can see, they often try to not let that out in front of a jury because it's embarrassing. And
well, especially if you're 18.
Yes, having everyone staring at you is very.
And it was nationally televised.
Being a young man too, that the gender part of that also might have an impact.
And I think also being the defendant in the case also has an impact because you don't want the jury to perceive that you're trying to make yourself a victim. Like there's a lot that goes into that, but it being in the room, how did the jurors respond? How did other counsel respond? Because it looked like the second prosecutor, not Binger, who I have very strong feelings about in a negative way. It looked like he was putting his face down and dabbing in his eyes. Like it looked like there were emotional responses in the courtroom, but it's very hard to tell when you're not there.
Okay. One thing, emotional response, I couldn't see Krause's face at the time. I mean, because I was looking at Kyle. I was looking at Kyle and I was looking at the jury. Well, actually, I don't even know if I could see Kyle really at that point, just because of from where I was and where Mark was kind of between the two of us. I don't know if I don't think I saw it when it started, but I could see, but you know, you can feel when the room gets instantly quiet. And it was a feeling type of thing. And I don't think I could see Kyle at first, if I remember correctly, but I think Mark moved and then I could see him. And I mean, my first thought was, I was like, he left his water bottle on the table. Like, you know,
Right.
He was nervous drinking fluids throughout like the whole thing. But, you know, we were worried about him and the judge was too. I mean, it was a genuine response and the jurors felt it. I mean, like I said, Joelle and Demetrius, you know, we talked to her afterwards. She's in farther back in the courtroom. You know, the only thing I remember hearing at that time, besides Kyle, and, you know, there's always some sort of background noise, is I remember hearing snaps from the cameras and I could very distinctly hear them because from the two pool photographers, because that was the only noise in the room at the time.
Wow.
Were them trying to take pictures of Kyle and trying to take pictures of Wendy. Is nothing.
Wow.
No, everything else was just, you know, dead silent.
So someone else noticed that right before the verdict, that you and Kyle linked pinky fingers. Was that like for good luck, or is there any story to that?
Oh yeah, I mean, not a great story. So I mean, we didn't have a lot of time between when we found out there was a verdict and getting things ready, and like we had to be ready to go. We basically had like grab bags because as soon as this was happening, we were getting out. And I didn't get a chance to like hug him upstairs. And this was more like, you know, we're here. That was, I mean, yeah, I didn't get my chance to hug Kyle and I didn't know if I was going to be able to. And, you know, I don't consider my clients my friends because they're my clients, but I care about all my clients. I mean, that's just who I am as a person is, you know, I'll be straight as hell with you and I'll be telling you if, you know, I think you're making a good choice or a bad choice, but at the end of the day, it's not my life. And, you know, I really don't hug clients. Often I try not to just because there's certain boundaries that you need to keep, but you know, I spent 3 weeks straight just with that kid, that in and of itself. And, you know, it was more of, you know, I'm here. It's a gesture. And I didn't realize anybody could see that. There were benefits though to the stream. And I mean, I told Alita with Gage Grosskreutz testimony, he mentioned the word head trauma. And that was something that Alita was like, I hope they bring that up in closings. And
I did.
that was the one thing. I don't think there was anything else specifically from the streams that really got incorporated.
That's crazy.
Yeah.
Oh my God. That's
yeah. All of the LawTube street cred right now, Natalie. We appreciate you.
Well, I mean, it was that was something that, because I had wanted to go back and rewatch it, that I was like, okay, this is something that I didn't pick up on at the time, that there was this great response to. Pretty much everything else, we were able to. Or, there are some things that just like don't matter because people aren't there and aren't looking at the jury. And that's a lot of, we're very good humored about criticism, things like that. I mean, first of all, if people haven't ever been, even if you're an attorney, if you've never done a trial, we don't really care what your opinion is because you haven't done that. As far as
that is also fair.
As far as like a strategy, as far as like strategy goes, and we had a theory from the beginning, and it was one that Kyle agreed with, and it was what we stuck with, and it's what we won with.
And that, there's something really powerful about that, because if you have to take your trial from your opening to your closing, and you can't shift tracks. You can incorporate what comes at you, but you can't really shift tracks. You can lose a jury that way. So,
well, and the state proved that, because
absolutely,
Mark coming in with his closing. Binger had said in the beginning, you'll see him chasing, Rose. That went very quickly, went out the window, and everything is, not only is a situation where everything is available to look at after the fact. The jury isn't going home and watching YouTube every day, but they were there, but sometimes they need to be reminded of things. And so, when we're able to directly quote you that you had said this in the beginning and that never happened, it's either you aren't prepared and don't know your case, or you're trying to pull something over the jury's eyes.
I do want to know though, was there amusement with the reaction of the stream clips that went viral with Alita and
no, that was more of what it was, is like entertainment. It was just needed something to make us laugh during all of this. And
losing their minds over Gabe's response.
It was great. It was a great cross. It really was.
Yeah.
Tell Corey I said so.
I will. I've told Corey that multiple times, and Corey is a very humble and awkward about it. He's like, oh, it was good. No, Corey, it was awesome.
Not like law students take note. You won't always get these moments in court, but if you do, you need to walk away going, I had that moment in court, because I think that cross is going to be something used in law school to exhibit and show what a controlled and excellent cross looks like, because it's on TV and it's a case people are familiar with, and it just makes the practice of law so real, because it was really a phenomenal cross.
It was something that I was just like, that I'm in some ways, very humbled to be part of this. I know I've seen people saying things, and I think I mentioned earlier, why didn't it wasn't I involved more, because I didn't need to be. And it wasn't something that, and Mark and Corey have worked so hard their entire careers. They deserve every second of the attention they've gotten, and they deserve every bit of credit that is owed in the situation. I know that different people have different opinions about style, approach, things like that, which is all well and good, but they don't work in Kenosha. And Racine, the ability of both of them to connect with jurors, especially regionally, is such a big thing, because you get somebody who's from a big city, Chicago, LA, New York, something like that. And I think that had that been involved, things might have gone extremely differently, because this was a case about Kenosha, and so many people don't realize the state Kenosha was in at the time is, something that's not really talked about a ton. They've talked about a little bit, and Nathan Debruin went into it. It's just, there were so many buildings, like not even near the courthouse, that were just demolished. It was just burnt to the ground. And, there wasn't and this is something Richard McGinnis has also talked about, is because, he's been to all these different protests and stuff, different places, demonstration, is when we were doing research for the case, he had done different interviews and I'm talking about just how unprepared Kenosha was. And it was. And it's something that, there's so many factors that got into why we ended up in this situation. But the people who live in Kenosha know it best. They felt it best. I mean, I don't know how many people bought firearms because of this. There were witnesses that weren't brought in who, because they really didn't add anything to anything. One specifically that I'm thinking about who had given a statement that was, after these shots happened, them running away and, stopping to take a breather in front of somebody's house and the person in the house coming out with a gun about ready to shoot them because they're like, get off my property because of everything that's going on right now. This was a law. It was lawless at the time. There needed more help and they didn't have the help to do. There weren't the people. The National Guard should have been there after the first day and they weren't.
It's too like the prosecution was going to try to paint Kyle as an outsider, this across state lines. And it seems that the defense team really leaned into that to prove, no, this is our community. And it almost felt at times like Binger was the one from the big city who was trying to be a little more slick with the jury. And you can appreciate that. It's something we talked about a lot with the pronunciation of havoc. It was,
havoc.
It was
havoc. I loved it.
So,
I can't say it the same anymore.
I can't either, but it's so local. It's very local. And that is something that is needed. I felt like Binger was playing the trial, and please let me know your thoughts on this, that Binger was playing the trial to the national media and the defense team was taking this trial directly to the jury.
I think that that's a fair feeling.
Oh yeah. So I want to ask about putting Kyle on the stand because I know that was also something that when we were watching, we were like, no, don't do it, but obviously it ended up working out. The jury acquitted him. And I saw also Mark had a press release right after the verdict came in, and he talked about having a mock jurors, and he said that played much better with him testifying as opposed to not testifying. Was there any other information that you guys sort of analyzed, relied on in making that decision to put him on the stand?
Well, I mean, personal conversations that were had with Kyle about it, I really wasn't privy to. So I can't speak about, Kyle's thoughts or motivations with that. But where our position kind of came from it as well, it has to do with, again, idiosyncrasies of Wisconsin law, is with the self-defense instruction, it involves, there's the directive words is what the defendant believed was reasonable. And if it had been a different situation wherein he'd given a statement, something like that, an actual statement, perhaps we could have gotten away with that. But I'm honestly not aware of, that was something from the beginning. It was, are we even going to get this instruction if he doesn't testify? Because we don't get to go back after we close evidence. And, then it's, are we going to get the instruction or not? It depends upon what evidence we put on in trial. And it's all well and good having Joanne Fiedler and Nick Smith and Dominic Black testify what their observations were, but Kyle at the time was rightly in shock. He didn't, the little statements that he made don't really provide any basis as to what his belief was at those moments. And so we were worried we wouldn't get the instruction, if he didn't. There were times after that, so that had been something from the beginning that, we were very concerned about and was very much at play with everything was, can we even get this instruction if he doesn't testify? And it wasn't the time or the place or the case to maybe risk that.
Yeah.
Because that's when you get into malpractice type of situations. As people throw around the word malpractice all the time, well, there is a strategy for things, but that is something that, could have ultimately been a serious problem is if he hadn't done it. And with the mock jury that we did that with Joelle and Demetrius. Corey went in, gave an opening. Mark went in, gave an opening. And, at different points throughout, we were taking survey questions from these jurors. Joe Ellen's team had everything set up very well. You know, they were like tablets and sliders and how do you feel about different things, like tons of questions about everything. And there was, you know, they first get asked questions when they're first in there, what their positions are on the case. And they get asked similar questions, you know, at different points, and we can track their changes, things like that. And we had 2 sets of juries that watched Kyle testify, and 2 sets that, and rather 1 set that had watched the openings, but then just watched videos during, in lieu of watching Kyle testify. And, you know, it was one of those data things. It was a night and day type of difference. I mean, and we also got to see their deliberations, things like that, their thought processes. And even in that abbreviated format where Kyle did testify in that instance, you know, it was just so completely different between the deliberations between the groups. It was very fascinating.
That was another thing that I was wondering, because I know that, you know, in a lot of cases, at least my experience in California has been that if you stand outside the courtroom afterwards, the attorneys can make themselves approachable, at least by the jury. But in this case, was there, I guess you already answered it, that there was no one that spoke to you afterwards. No one.
Well, I mean, at this point, I mean, Mark in and of itself, after every single case, will reach out to all jurors. After every juror, like I said, he's done over 100 as a criminal defense attorney, and every single time he reaches out to jurors. Okay. He's like, you know, you're under no obligation to talk to me. If you want to, I would love to talk to you. So, okay. You know, everybody needed to take a little bit breather after this was over. So, you know, us reaching out didn't happen right away. But, you know, I'm sure that there are some people involved in that on that end who are going to want to at least, you know, talk to Mark. There usually are people. Our office does that in general because we want to be good at what we do. It's one of those, some people, we've gotten so many people calling us, emailing us and stuff about defamation suits and whether we're going to be involved. You know, are we doing those? No. I mean, you can be a jack of all trades and a master of none if you want to. But like, we like being good at what we do.
How I feel sometimes.
Yeah. We like being good at what we do, and we know what we're not good at doing. And so we stick to what we're good at, and, you know, we want to be good as possible at it. So we always welcome feedback from people, which is why, you know, we take everything, criticism, stuff like that, you know, the internet's done with a grain of salt, is because, you know, I mean, you can hear things, but there's certain amounts that aren't going to necessarily impact your way when you weren't there, when you weren't the juror.
Right. The judge did have spectacular moments of yelling at people.
Oh, I know.
He did. It just is that common for him, or?
Oh yeah, he yells at everybody. Okay. But I was in Kenosha Thursday, and he has seen your merch, the Brazen t-shirts.
You're kidding.
No.
Oh my God.
He's seen them. Somebody linked them to him.
That's amazing.
Apparently he made some joke. He's like, so am I getting royalties then? Or something like that.
Well, I can definitely send him a free t-shirt if you want.
Oh, I don't know. No, I know that he's seen it, that he knows they exist though.
Oh my God. That is crazy.
Well, and I told you the Richards Hocus Pocus Out of Focus shirt, you know, as soon as I saw that, I texted it to him, and his wife, Nate, is also, I mean, he had been subpoenaed he met with the state, and like he said on, you know, his interview, and I think on during his testimony, you know, he came and met with us. He was at first very, you know, apprehensive because he got our subpoena from us and was angry, I think, because he thought that we were the prosecutors trying to get back with him, if I remember correctly. But, you know, giving him the opportunity to tell his story the way he wanted to was, I think, the important thing for Nate. I also don't think people realize how crazy it is that he brought his own exhibits. Like, I had, you know, I had about 1 million jobs during the trial. You know, basically, who was doing, if you had a question, who was doing this, it was probably me. But so that day, managing witnesses and stuff, had spoken with his attorney beforehand. He had mentioned to me that Nate was going to be bringing pictures in. I was like, okay, well, maybe like a couple printed off or something. No, he came in with like 40 professional, like they were big. There were some huge ones. Like he didn't like the way he was treated, and he did something about it. And I admire that about him.
Yeah.
None of us liked the way he was treated. He was such an endearing individual, and he seemed very linear when he was testifying. It's like, no, it's A, B, C, D, and that is what I'm telling you.
Well, and that's how the jury, I mean, the masks were hard to tell. Not everybody was wearing masks. The people who wore masks usually wore masks every day. Some of those people, were hard to tell, but I think they thought it was coming across like he was trying to beat up on him. Yeah. That was the sense I got from them, is that was the perception they were getting.
That's the perception we got.
Yep. Yeah, that was exactly my thought as well. Another thing that he mentioned, I don't know if you happened to see his sorry.
It was like a tail.
Yeah, it does sound like it. It's not indie though. Sorry. Got a little distracted there. I don't know if you happened to see Nathan Debruin's interview with Nick Rekieta the other day.
I saw about 10 minutes of it.
Okay. He mentioned that when he was waiting outside the courtroom to go in to testify, that there was some man that said that he was some LA lawyer and came up to him.
No idea. I found out about that for the first time through. Okay. I think that was the first time I heard of that. That was, again, us being in the courtroom. But there were some big ethical problems that I had with a lot of things that were going on. I can't speak personal basis because I don't know people's motivations, but there were weird things going on. And unfortunately, I can't really get any more in detail about that because all I am doing is operating off my own suspicions and stuff. And I also don't want to identify anybody's names because some of these people are still potentially involved with things that Kyle's dealing with. But there were weird things going on.
Well, even just watching, for us watching the prosecution not turn over like the full file size and things like that. When we can
finally talk about that.
Yeah. I know. Everybody's been waiting for it.
The tech stuff, and I left the LA County District Attorney's Office almost 5 years ago. So evidence and digital evidence has changed tremendously in that amount of time. But I was so outraged. It's such a basic thing to turn over, making sure everyone has the same copy of everything.
Yeah. But so what happened was told that there was this footage. I was told that it had been dropped off by this individual. We obviously wanted the footage as fast as possible. I was like, can I get it on a flash drive? Well, they didn't have it a flash drive with them there. I would have to go over to the RPD to get it on a flash drive. The problem with that was, like I had mentioned earlier, for security reasons, they didn't want us going anywhere. It's just like that would have been a hassle. Like if we had been, and being respectful of the situation and the people that were trying to help us, and also my personal safety, like I don't want to necessarily run over to the police station and deal with this. Personally go. I didn't have a car down there. It's not far away. It's just a couple blocks, but still like, and there were also it was just not the ideal situation to happen. But we wanted it as fast as possible. So I believe I had asked if it was something that could be emailed to me, and because some files are too big, and also I'm not a tech expert. I'm just under 35 and competent.
You sounded like a tech expert.
You're a tech expert in a law firm, by the way, because
no, I am the tech expert in my law firm because I'm the youngest attorney here. But and I can, like open documents and print things. I'm really fancy.
Attachments and email. I know how.
I'm proficient. Yeah. And I was told it could be emailed. I didn't have any reason, and I get this file. We look at the file and we're like, okay, this is basically the exact same. I mean, it was a little bit, it was a higher, it was a, you know, bigger effectively, because on Tucker Carlson, it's just that little thing in there. And if you're going to isolate it, you know, there's a certain amount of distortion that's going to happen when it gets larger. But it wasn't anything new. There wasn't any information in this video that we really were like, oh, okay, well, we just finally have this file. You know, woohoo. We also, so we had looked at it in that aspect, but when that file had been played in court, you know, this was also before we had brought in the high def TV in. We brought in the high def TV, the 4K TV, because John Black said that we should. When we were going over when we were going through stuff with him, you know, going through demonstrative stuff like that, there was, you know, on his laptop, there was some detail that you could see on his laptop that wasn't on the screen. And we were like, okay, well, we want to make sure that, like, for you, we've got all the details, stuff like that taken care of. So we brought in this TV, but like the monitors that we had in front of us aren't 4K monitors, the ones that were on our table. The TV that we could see is the one in the corner, which is far away and is also not a 4K TV. So, I mean, it had been played, but I mean, there was nothing discernible from what had happened, because, yeah.
Oh, sorry. I was going to say, so how many days was it until, well, when did you first realize that you didn't have the full resolution file?
That day we were dealing about it in court, and they said that it wasn't the high resolution file. We had I had no reason to think there was any problems beforehand, because I mean,
because they would just say we can't email it if they couldn't email it.
Yeah.
You would never think anyone would compress it and email it.
And I really don't know how things happened with that. I mean, I have my suspicions, obviously, but part of the problem with this is that in the arguments that were made in court, stuff like that, is there were a lot of assumptions that were being made that were not informed, that were being presented as fact. And I don't want to make that mistake. You know, I'm first to admit, as I mistakenly first was like, you know, and I think somebody had brought it up because it's in the video, you know, I got that from Dropbox from you. Well, I realized, you know, after the fact, no, that wasn't what we got. I had gotten on Dropbox. We gotten everything else from the state crime lab on Dropbox. It was just kind of in the moment, you know, you know, after I thought about it, I'm like, oh, no, that's not actually how I got that. But, you know, we didn't have any reason to believe it would be different. Everything else had been turned over to us on disks, on flash drives, on hard drives. This was, you know, I had noticed things with metadata previously that were a little bit weird. Like there were some, but they all were chalked up to camera stuff. Like there was some, like police camera, for example, that they're doing evidence on, that like the day was one day off type of thing, or like it hadn't accommodated for daylight savings time. There were things like that I'd noticed previously, but you know, that had been accounted for like otherwise. And we also didn't, so we get this file and we don't get the report on it, that because they had taken, the state crime lab had taken the file, they enhanced the videos, and they also did those stills. As we also, you know, didn't get that report right away because they didn't have it at the same time as the video. So, you know, it wasn't, because the state turned it over to us as soon as they, you know, we thought as soon as they got it, and then they separately sent it off to the state crime lab. So we don't get their report about these things until days later. So, you know, things like that, like the file name, metadata, stuff like that was over. You know, first of all, there was nothing in the report about the file size or the metadata. Really, the only thing in the report that indicated anything different was, like I'd mentioned in court, the receipt, the file name, because they always in the state crime lab rename things. So, you know, for their own working purposes.
I was wondering where the file names came from. I'm so glad you clarified that.
So there's
was doing it.
Yeah, that's where these file names came from, because the state crime lab was doing it. But there was, you know, the original file name receipt that they'd gotten, they indicate should have been the exact same one as that we had gotten. But we didn't notice it was until that there was any discrepancy until we were looking at the high def TV, and Krause was like, is this the good version or something? And it's like, this should be the only version. If there's another version, that's the problem.
Good version. See, there's case law that says the version you have and the version I have are the
Should
same.
be the same.
Yeah, there should be. And
yeah,
I don't know the intention on things. I'm not going to speak on because, again, I don't know. But
yeah, because we got some questions on that. People wanted to know if you thought it was intentional or not.
Well, and that was something actually that was something that actually. Well, first of all, I don't think that Dinger had anything to do with it. He was nothing but forthcoming with me about that stuff because the only reason I found out that what the actual file was is I got it from him. And he asked me after the hearing, when we discovered all this stuff, if I thought they had intentionally given the wrong file. And I was like, it doesn't matter what my opinion is on this stuff.
So there was also like the dimensions of the file.
The aspect ratio and stuff. I know there are the issues with that. That was, something that when that is also an issue. I mean, that is, again, I don't want to speak on things that I don't know a lot about. Like I said, I'm not a tech genius. I'm just very proficient, and I can tell that numbers should be the same. Right. It's like, I can do math.
Where to look for the metadata.
I know where to look. And I'm like, I can have other people describe things to me. I'm like, this is like, why doesn't this match up with that? I know reasons, I've got the predicate knowledge to know that certain things should match up, but how things go about getting changed, other stuff, is beyond my personal knowledge. But I do know things like, the file name's not going to change if you're compressing it. That's not going to happen.
Yeah. And on that, another question that I got from people was, so when we were watching, we started to get a lot of feedback from viewers, like a lot of DMs, emails, all kinds of messages from people about, not just about the various qualities of this video and their own analyses of it, but also they went back and looked at
the handbrake. Yep, I know
exactly.
Yep.
Did you guys notice that?
Well, not at the time, but I mean, we probably had at least 400 people between phone calls and emails let us know all about that. But our tech people picked up on, after the fact, because we looked back at different times and things. And so I think we were one of the tech people we had dealing with stuff had noticed, had went back and found the timestamp as well. But it was, something that at the time it was happening, it doesn't, necessarily mean anything to you having it be on there. And part of the issue that we even know about that was because they kept their laptop plugged in when they're switching between programs. And Rakita actually had mentioned something about, because I had it with mine, like minimizing out and doing other screens and things, because originally I hadn't. But there's just this lag between like plugging things in and getting things displayed. And there were issues with that Corey and Mark weren't happy with. And I was like, that's fine for if we want to do it that way. I just have to, scrub certain things, make sure that when I've got things up that, I'm not like accidentally showing something I shouldn't be.
You don't want to in the YouTube world, like expose your DMs because you're switching screens and you've got your Twitter DMs open, which happens to live streamers all the time. And you guys were experiencing that in real time in trial.
Yeah.
Were you using your personal computer, not like a computer for that trial that was just scrubbed to do?
No, that was not my personal computer. It's the evidentiary laptop. I mean, I'm actually on it right now.
It was the evidentiary laptop.
It was a laptop we bought specifically for this trial. There were certain tech specs, things like that, trial assistance programs that we wanted to have. We were like, okay, we want this. We talked to tech people. We're like, you need to tell us what computer to buy that we can do these things. And so we did that. And the only thing that the computer had been used for was this case, and then like Zoom court when I'd done like various other Zoom hearings, because it was like I was working on this computer anyway, so I might as well just bring it up when I got to do Zoom on a different case. But otherwise, that was the only. After there's still some saving of things that needs to be done. because, there's obviously other issues going on, and we don't want to accidentally, inadvertently not have something available if Kyle needs it later. But that's the only thing that this computer was bought for this case, to be used on this case.
So do you think that sort of changes the way that maybe trials are done with, I mean, obviously so much technology is advancing, and that's very common in the legal profession, that a lot of lawyers are not particularly adept. And that's why there have been a lot of updates to professional rules across a lot of states, is that is now an element of competency for lawyers. So do you think that there's likely to be sort of a change in the way that courts maybe do things, maybe at least in Kenosha? I don't know.
I don't know. Part of the problem, honestly, is an extent people being in control and in power over these things, being unfamiliar with them themselves. So it's hard to appeal to somebody who doesn't know why this is important to tell them it's important. So I have my concerns based on things like that. Also, the judicial system in itself is always very behind on technology. That's just if you look at case law, stuff like that, that's like the judicial system doesn't deal with new technology and the problems associated with it, and usually until after the fact when they've been a problem. So if I have the exact same thing that they have, I should have the same file name, I should have the same size file, and it should have the same metadata. I mean, that's just putting it simply. I did not have those things. So if you have something that has 3 times as much information than what I have, it's not the same.
Rules of discovery do require that they provide you exactly what it is that you are entitled to. So that's their burden.
Yeah. And I've seen people are like, at different points, well, it's not a fair standard. Yeah, and it's not a fair standard.
Because somebody's going to
prison. Yeah, that's how it works.
Those are the rules. Those are the rules, though. And
that's the thing, is that they should have a greater burden, because they're not going to prison at the end of this.
You want, and I am a former prosecutor, you want the weight of the government to follow the rules. They have the resources, they have the money, and they have the power to deprive people of life and liberty, depending on what state you live in. They should have the highest standard to do that. And when they don't, that is what damages our justice system. When the people with the power don't play by the rules, that's where the damage comes in. And I think that's why it was so outrageous and offensive, because a lot of prosecutors go over and above and beyond to make sure everything is turned over, everything is clear, there are no mistakes, making sure their detectives have told them everything, sitting down with everyone with binders of evidence and flipping page by page. And they didn't seem to give a shit enough about doing their jobs in an upstanding way to make sure that things were taken care of. And then they were smug about it. It's where I felt so deeply outraged. And I'm and it's just not good for our system. There has to be a balance.
People don't take care of their mental health enough. And all I really want is just to be happy. That's like my goal for myself, is to be happy. And, I, especially the past, dealing with all of this during the same time, dealing with such a stressful, high profile case, is that, I've said to my friends, like, I don't, most of my friends, I don't want to say that people didn't know I was doing this, but I mean, I also didn't talk to people about my dad being sick, is because that's just kind of the person that I am, and I got to get through it. And, now is more of the time that I'm dealing with these things. It's kind of part of the grieving process. But, at the time I couldn't get into it. I needed to sleep. I don't have to waste my time talking 3 hours a day, justifying to everybody why I'm doing what I'm doing, because that doesn't serve me. So,
well, I think it speaks a lot to your integrity that you're open to talk about being ethical and great at your job, and also taking care of yourself as a person. It's something that lawyers aren't willing to talk about. And especially, I think, female lawyers, there are a lot of firms. It was nice to hear you say that Mark, as lead counsel preparing for trial, was so supportive. I know that's not going to be the experience for every lawyer that was going through personal stuff. It's like, yeah, we all have personal stuff. I need you to deal with this. And And that's something I've dealt with in my profession, legal bites. I'm sure you've dealt with it too. Where
Oh,
it's,
yeah.
yeah, everyone has a life, push through. Like, what's wrong with you?
Yeah.
And so it's really nice to hear that the culture at your firm is, we do great work, but we're also people, and we're taking care of that. It's just encouraging to hear.
Well,
Absolutely.
and I mean, we, that doesn't mean that we don't, I don't want to tell you how many hours we put into this case. Like I said, yeah, it's not that we don't do our jobs, but it's
humanity of it. There's a way
yeah.
to work all the time with humanity, and there's a way to work all the time as robots with no human. There's two ways to do that. Of course, you nonstop.
Of course.
And yeah, that's just how it is. And that's the reason why we have a small firm and the work with people that we do is because it's not something that everybody understands. But we do these jobs because it's important to us, and it's important to hold the state accountable. It's important to hold the police accountable. It's important to hold the community accountable. Everybody, there's just so much more that goes into it than I think a lot of people realize, especially for people who are criminal defense attorneys. I mean, when I first started doing what I do, it's the how could you defend criminals type of thing. And it's like, don't just eye roll type situation.
Keep the government from overrunning people's rights. Let's reframe.
And that's the thing is, if I just want the people who have the power to take away somebody's life and livelihood, that somebody makes them do their job the way that they're supposed to do their job.
Absolutely. All right. Well, should we start with the memes?
I would love to start with memes.
Okay, let's do it. Okay, so
right now,
what's that?
I said I love that this is happening right now. I'm sorry.
This was all Natalie's idea, by the way, guys.
And I also haven't seen. So Alita sent some to me earlier to have me vet them first. I thought it would be more fun if I didn't. But, so there might be some things that I can't. That I will be unwilling to speak about, but so we'll just pass those if that happens.
Sure.
You can always just funny or not funny if you
you'll see my response.
So actually what we'll do is we'll have a particular rating system. You'll give between 1 and 10 Grambos. 10 Grambos is awesome. 1 Grambo is not awesome. I didn't want to be too harsh with Binger and Krause because I know you wanted to keep things professional.
Yeah,
but I thought this one was kind of funny.
You know what the thing is, though? Actually, knowing Binger, I'm sure he appreciates this one too. Actually.
Oh, okay.
So, this one, I mean, I love anything that's a shout out to Duck Hunt. It just looks absurd.
Yeah.
I mean, I'm probably going to give it a 10.
Oh, all right. Emily, what do you think?
I'm giving it a 10. And again, I have childhood affinity to Duck Hunt. So, and it's just funny. And it was so well done. Like, they've got his finger on the trigger, and it's just funny. It's clever. It's funny. But
the word vigilante to refer to your client since the verdict came down. How do you react to that?
Maybe they should have watched a trial. Yeah.
All right.
Oh, that's another 10 for me. That might actually reach the 11 point for me. Just
I love where they froze him with the shoulders up.
That's the he doesn't smoke cigars or anything. Oh no, that's a joint.
Yes.
That gets an 11 out of 10.
Nice.
11 out of 10. I love it.
And this, I'm not saying that like it was necessarily needed, but the reason why I wanted to be on this show as opposed to like when Sean Hannity and things like that were trying to get me on them is I want to pay it forward. I want the world to be a better place because of me. I want your career to be a better place because I'm here. So if anybody wants to do anything to support me, let's like and subscribe Legal Bytes and Emily Baker. Let's, if you don't, I don't know, what's the click the buttons, whatever. So follow them because they're, that's kind of what I wanted to do. Nate Debruin, anybody, I want to pump people up.